Hello, I'm Locke Meredith. I'd like to invite you to join me on the next Legal Lines, where I have Sean Fagan, my partner. We're going to talk to you about the litigation process, from hiring a lawyer to providing them information to seeing the right type of docs and then putting together a settlement package, and most importantly, mediation. And then we'll continue with future shows taking you through trial and possibly appeal. So join us on the next Legal Lines with Sean Fagan. Hello, I'm Locke Meredith. First of all, I want to thank you for considering our firm for help in handling your legal matter. We know what we're doing. We've been around for a long time. We have over 60 years combined legal experience as lawyers. I've been practicing over 30 years, Sean over 25, and I have paralegals and legal secretaries who've worked for me for over 27 years. We've handled about every kind of case you can handle, and we've been very good at it. The bottom line is, it is our goal to be your protector when necessary, advisor, negotiator, and to successfully conclude the litigation for you in a way that is very favorable. Knowledge is power, and the folks who know what they're doing empower you. They enable you to make the right kind of decisions that best serves you. And that's our number one goal, frankly. Our number one ministry is to serve you. Hello, welcome to Legal Lines. We're going to do this show a little different. My partner and I, Sean Fagan. Sean, great to have you back on. Decided to kind of talk to you folks about the litigation process. So Sean, we've been doing this stuff a long time, and you know, we've got some experience now behind us. And folks, as you and I both know, are real nervous about having to get involved in the kind of legal system. So I figured we kind of talk to it just between ourselves and kind of explain to folks how the process goes. So let's start first with, how do they find a lawyer? Because good Lord, lawyers have bad names for the most part. Very few justifiably so, but people are not real happy about having to go see a lawyer.
Well, there's a lot of pressure because you feel like, okay, well, I'm going to see a lawyer, people to be talking about me, trying to make an easy payday, that sort of thing. But in our practice, generally, you know, the folks that we're fortunate enough to represent are folks that are coming in, they don't know what to do. Yeah. You know, they may be a baker, a doctor, any other
Doesn't matter
profession.
what your profession is or what you do for a living. This is something they don't know anything about usually.
Yeah, so they walk in, and usually for us, and I know it differs for all different law firms and how they do things, but you know, for us, generally it's from referrals from past clients, family members, things like that. And then they would just call and ask a question.
Well, let's talk about the factors that when they are looking for a lawyer, what they need to look at. And in my view, you know, you need to find somebody who kind of has focused on the type of problem that you're dealing with. You know, the laws are so massive. It's just incredible how many laws we have on everything. And so if it's a contract matter, you need to probably find somebody that focuses on that. Injury matter focuses on that. Government, you know, discrimination. Lawyers pretty much specialize and focus at least on a few things instead of trying to do it all. Now, there are some who try, but I would advise folks, first find somebody that clearly has been handling the type of problems that you're having at the time.
Oh, without a doubt, if you're doing, like we do some medical malpractice, we do you know, tort work, but I'm not going to really touch anything that's real estate. I know enough to be dangerous in real estate. But if someone calls
or
and
bankruptcy.
Says, yeah, or bankruptcy, there's all sorts of areas of law that we don't practice in as much. And so if someone calls me, I'll give them my best advice, but then tell them you need to contact somebody else who specializes.
And sometimes
in this area.
we'll refer them to folks
Yes.
we know that specialize in those matters. So it would be that. I would say another factor is make sure you're relaxed. You think you kind of investigate, and you can go check and see if there's ethical complaints against lawyers. And you can ask around. As you pointed out, we get a lot of past clients or friends that refer us folks based on past you know, experience with us. And you can ask folks around that you think either have already had that situation or might you know somebody that has. That's a good source of referral. So let's assume they've chosen the attorney. They go in, kind of describe the process, at least, you know, as far as we're concerned.
Well, the first thing is you ask questions. You know, have you ever done this kind of work before? And that's a question that every attorney should feel comfortable answering. asking, how the fee structure works, because that's another.
That's a big deal.
Yeah, it's how, how does this work for me? What does the lawyer do? What do I have to do? And in general, if it's a personal injury action, the idea of the lawyer's job is to take all the pressure off the client when it comes to all the legal side of it. Let them concentrate on either getting better, going to see the doctors, whatever they have to do, and our job is to deal with the insurance company, gather the information, and then relay that to the insurance company, whatever necessary. But that's all questions they should ask in the beginning, because they need to know up front what they can expect.
Yeah, and I would say, after, and 99.9%, I would say probably 100% now of all the injury kind of lawyers, at least, the first consultation, the first time you go meet with them, is not going to cost you a penny. And it's better to bring in all the documentation that you have, whether it's a police report or medical records or letters from insurance companies or somebody who thinks you're at fault. Anything related to the matter, you should bring it in, because that helps the lawyer figure out whether it's a good case and what are the issues and what are the problems and what treatment might be needed. Because it's very important for both the client and the lawyer to have a good idea of what the problem is and what the facts are, so the lawyer, the attorneys, can best help that person.
Yeah, more information is better.
Simple way.
Give us more, and we can give you the better
and don't
idea.
hold back on anything that you think might hurt your case, because you might have in your head that if you said something or something had happened in the past, maybe previous injury, or treatment or anything, that might hurt your case, so you don't disclose it. The only thing that'll hurt your case about that is if you don't disclose
That's
it.
right.
Because then the lawyer can't be prepared to deal with it, and oftentimes it is not detrimental to the case.
The bottom line is, you tell your folks, just tell me the truth.
Right.
And let us go from there and deal with the other attorneys or the adjuster. But to withhold information from your lawyer is the single worst thing you can do. Because if the other lawyer is doing his job,
they're going to find out.
He's going to find out whatever's there. And so I would much rather know up front, so that I can know how to evaluate your case, tell you how things should be handled, and go from there. But being honest with the lawyer is first and foremost, the best way you can assure yourself the best outcome you can come up with.
And just as important, you need to feel like the lawyer is trustworthy based on your encounters with them, the questions you've asked. You need to feel comfortable enough to tell them everything, because that's a very scary thing to do oftentimes, whether it's you've had a previous criminal issue or previous divorces or family matters or whatever. All of that stuff can kind of circle around. But as long as you believe and trust in that lawyer, and the lawyer believes and trusts in you, you're going to get the best possible outcome.
And some of that information isn't even relevant to the case.
Right.
So the fears that the client can have of, I don't want to go into this, don't want to go into that, are things that really don't matter to the case itself.
Right.
So that's one of the things that the lawyer can do, is to give you some assurance that this isn't filleting you where you're wide open in front of the world. There are going to be things that matter that are just germane to the case, and the rest of it doesn't matter.
And you brought it up, but the contract is a big deal. The contract for services of an attorney is a very big deal, and so they need to be familiar with it. They need to be given the contract to read. They can ask questions of every word that's on the page. What does this mean? I don't understand it. I don't like it, whatever. And then, of course, the most important thing is, how much are you getting paid? And if there are expenses associated with my case, and you put out money out of your pocket, lawyer, am I going to have to pay you back for that? Or are you just going to get that out of any monies that you get for the suit? And there's all kinds of provisions like that. So that's very important to know what you're signing, because you're signing it. Now, you can ultimately fire that lawyer if you don't like the way they looked at you one day. That's fine. But that contract has a lot of power, and you need to be very sure you know what it means. So let's kind of shift gears a little bit. Let's say that the client has hired the lawyer, and they're now meeting. We talked about the information they're going to provide. But the next step is, the most important step, is to get treatment. So let's continue that on the next segment. This is Locke Meredith Legal Lines. My law partner, Sean Fagan. We're talking about the legal process. Hello, I'm Locke Meredith. First of all, I want to thank you for considering our firm for help in handling your legal matter. We know what we're doing. We've been around for a long time. We have over 60 years combined legal experience as lawyers. I've been practicing over 30 years, Sean over 25, and I have paralegals and legal secretaries who've worked for me for over 27 years. We've handled about every kind of case you can handle, and we've been very good at it. The bottom line is, it is our goal to be your protector when necessary, advisor, negotiator, and to successfully conclude the litigation for you in a way that is very favorable. Knowledge is power, and the folks who know what they're doing empower you. They enable you to make the right kind of decisions that best serves you. And that's our number one goal, frankly. Our number one ministry is to serve you. Welcome back to Legal Lines. I'm Locke Meredith, and I'm having on the show today my law partner, Sean Fagan. We're talking to you about the litigation process and frankly, to not be scared of it, or at least know what it entails. So we've talked about kind of the process of finding a lawyer you're comfortable with, kind of the process that you go through, them meeting you meeting them, exchanging information. Be careful, read the contract, know what you're signing. The next step is for the lawyer to start collecting information. And frankly, if the client is still suffering from their injuries, in our case usually, we want to get all the medical records, and we want to make sure that they're seeing the right docs. So let's talk about that.
Yeah,
information collection.
And in the beginning, very rarely the clients come with medical records, right?
Right.
So we'll interview them, as you said, to find out what the problems are, what happened, what's hurting, what's not hurting, so we can get a baseline of what we're dealing with. We'll have the client sign authorizations, because obviously a medical provider can't just send medical records to anybody. There are laws about that. So the client will usually sign some documents that let the attorney get the medical records that are necessary to review what's going on.
And let's point out here that it is one of the first things we do when a client hires us is send out a letter of representation to anybody that we know of, and particularly any insurance companies that may provide liability or any type of insurance coverage, to help that client incur all the expenses and get them paid for and get proper medical treatment and such. And the reason for that is so that those individuals cannot call up the client and try and do recorded statements or get them to sign medical authorizations or anything like that. It's to protect the client from someone coming in and kind of milking them for information and trying to get them to say something that might be detrimental with them not even understanding it.
Which is one of the reasons why, one of the dangers there, because no matter what insurance company it is, and it doesn't mean they're trying to do anything,
wrong,
nefarious,
but their job is to find a way why they don't have to pay money.
That's right.
That's the bottom line.
That's true. It's a business, and so if you have somebody who does it every day and they do interviews every day, they know how to ask questions,
and they know what questions to ask,
and they know how to ask them in a way that you may not even realize what's being asked.
And you're guessing, or you don't know for sure, but you're going to guess,
and so
it's just not the right way to disclose information to an insurance company.
It just winds up sometimes, at least what I've seen in my practice, is you walk in and you realize that the person was asked to sign something and it was never explained to them, and they have no clue what they signed, and you have to give them the bad news of, hey, look, you signed this, and unfortunately you waived your rights, and they had no idea they did.
And let me say something right now, folks. Even if you don't hire a lawyer, if you are thinking you're going to handle the case on your own, and so you're going to negotiate it, and they send you some documentation to sign, you got nothing to lose by going and seeing a lawyer and asking them to review that and explain it to you and make some recommendations to you. You don't have to listen to the lawyer. You can do whatever you want, but it's in your best interest to be educated, because knowledge is power. And knowledge enables you to protect yourself in the best ways possible.
Yeah. And most lawyers are willing to give advice. I mean, I know we get phone calls all the time, and you try to help anybody as best you can.
Over the phone.
Yeah. And so, it's one of those things that at the end of the day, and I guess we didn't really touch on this part of it, but when you wind up hiring a lawyer, the lawyer is only going to do two things for you at the end of the case. He's going to say either this case should go to trial because what's being offered to you is not fair, or he's going to say this is a fair amount and we think it's reasonable. Those are the two things that are to come out before the case is completely concluded, right? And either you trust that the lawyer knows what he's doing and that he's knowledgeable and that he's looking out for you. And if you can't say those three things, you shouldn't be hiring that lawyer.
Well, and here's the bottom line too. Even though that lawyer tells you, hey, I think you need to take this money, or I don't think you should take this money, it's not enough. The client is the boss.
That's right.
That's the bottom line.
We
They
give
decide.
advice. We give advice.
We're advisors. We're counselors at law. So now we've gotten information in. We know perhaps at least who some of the parties are that may be at fault. And explain to folks why fault and multiple players may be an issue.
You might have an accident where there are multiple cars involved. What's the sequence of events? And that sequence of events can determine, who owes what.
Because in Louisiana, fault is allocated. If it's just one person who rear ends you, clearly they're the person at fault. But if somebody hit them and then shoved them into you, maybe the one in between might not be completely at fault. In fact, may only be 25% at fault or not at fault. The party behind who hit them first, shoved them into you, may be 100% at fault. So fault is allocated, and how it's allocated by the court determines how much money you get from those folks.
That's right. In other words, an example would be, let's say someone's speeding and the other person made an illegal turn. Both of them did something wrong, and so you got to figure out how do you allocate fault in that situation. So, even though, the person may not have be completely blameless, you still need to sit down and say, but you can't absolve the other person of responsibility if they're to blame also. So there's a lot of complexity to it that you have to address.
And the defendants, the folks that we're going after, if they have an insurer and lawyers, they're always going to say the person in our practice who we represent, who is normally the plaintiff, they did something wrong, or they weren't really hurt. And so they're trying to prove that at least our clients would be partially at fault, and therefore any judgment that was awarded in damages is not going to be paid in full by them. Let's say the court says our party, our plaintiff, our client is 50% at fault. It's a $100,000 judgment. Guess what? They only get $50,000 from the at-fault party.
That's right. Whatever percentage of fault is attributable to the client, that's what they don't get.
That's right. So we kind of talked about those elements. You've got multiple insurers that we're looking at, people who may pay, whether it's MedPay, insurance, and let's talk about these, or liability insurance. There's different ways that a client can be compensated for their injuries. Explain that.
All right, so if you hit somebody else, you're at fault. You're driving your vehicle. You run into another car. That other person makes a claim against you, your liability insurance kicks in. Why? Because you're liable to that person, and your liability insurance covers you up to whatever limits you've got.
And in Louisiana, we have minimal limits. What are they?
Minimum limits is $15,000 per person, up to a maximum of $30,000 per accident if you look at the minimum policy. And then if that insurance is not enough, you have uninsured motorist coverage, which is a separate coverage that automatically comes with Louisiana insurance policies unless you waive it.
And that's a big, big deal. Insurance is probably the insurance that I wish our clients had, every single one of them, because we've had so many circumstances where their injuries and their damages exceed by hundreds of thousands of dollars the amount of liability insurance the other party who hit them has. They might have $25,000 and their damages are $100,000. Guess what? They're likely only going to get $25,000 unless they have uninsured or underinsured insurance, insurance, in which case, depending on the limits, they will pick up maybe that other $75,000.
And we need to hit that in the next segment. That's important. Can't overemphasize the coverage.
All right, and then there's MedPay, and of course we look at that and we'll discuss that. So we'll pick this up on the next segment. This is Locke Meredith Legal Line, Sean Fagan. We're talking about the litigation process. Hello, I'm Locke Meredith. First of all, I want to thank you for considering our firm for help in handling your legal matter. We know what we're doing. We've been around for a long time. We have over 60 years combined legal experience as lawyers. I've been practicing over 30 years, Sean over 25, and I have paralegals and legal secretaries who've worked for me for over 27 years. We've handled about every kind of case you can handle, and we've been very good at it. The bottom line is, it is our goal to be your protector when necessary, advisor, negotiator, and to successfully conclude the litigation for you in a way that is very favorable. Knowledge is power, and the folks who know what they're doing empower you. They enable you to make the right kind of decisions that best serves you. And that's our number one goal, frankly. Our number one ministry is to serve you. Welcome back to Legal Lines. I'm Locke Meredith. We're talking to you about the litigation process. My partner Sean Fagan and I are kind of explaining it, hoping it clears up any issues or fears that you may have. We were talking about the types of insurance. There's liability insurance, insurance, MedPay insurance. There may be health insurance. You may be getting Social Security benefits or coverage through Medicare, Medicaid. All of those things play a role in this. So explain.
All right. So the type of coverage that most of us get, regular Joe Blow on the street, you're going to have liability coverage. And liability coverage, the best way to summarize that is that protects the other person.
Right. Does nothing for you.
Yeah. The coverage protects you. It protects you from somebody who has no insurance or someone who doesn't have enough.
And they hit you and hurt you, and you have damages.
That's right. And so it's a way for you to make sure that you're not really left with a huge bill and no way to pay
Instead of you suing them and getting the payment from their insurance company, you're actually going after your own insurance company because you've been paying them money every month to cover damages that you couldn't get from them.
That's right. And then there are other coverages that are usually available to you through your own policy. You get MedPay coverage. That's if you have medical bills that are related to an accident. Doesn't matter who's at fault. You're in a car, you get in an accident, it will cover you up to a certain amount that you've purchased. So then you go beyond that. People have health insurance. That brings in a different layer of issues because you've got
or disability insurance, Social Security. All these folks, they may be helping pay for the bills, but guess what? They get it back.
That's right. At the end of the day, you have to reimburse them for what they're essentially fronting you for your medical bills if it's your health insurance.
That's right. In essence, they're like a bank loaning you money to pay your expenses, but they have a mortgage against your lawsuit.
But then what a lot of people don't realize is that sometimes the person that causes the accident, they might have a first layer of coverage, and let's say that layer of coverage is X number of dollars, and you think, wow, they don't have enough insurance, but they might have excess coverage. And so again, these are things that if your lawyer is looking at the different issues, they may come into play and they may be.
And that often arises where it's an employee driving a vehicle and the employer has a basic underlying policy for vehicle accidents and such, but then they have this giant excess policy that picks up after $100,000 or $250,000 or $500,000 or whatever the contracted number is. It might pay $10 million more in insurance coverage.
And if somebody has a catastrophic injury,
that's a big deal. So let's move forward now, because we could take all day long explaining this stuff. But so we get the insurance information. We get the treatment information. We make sure our clients are getting treated by the proper medical specialties. If they have particular injuries that require, say, an orthopedic or a neurosurgeon or a neurologist or whatever. Brain injury requires a special type of doc. And so make sure they're treating, and once we know they're treating and that they've either healed up 100% or that the doc has done everything for them, what's the next step?
Well, we gather the records, gather the medical records, make sure that there's light at the end of the tunnel. You have an idea of what's going on, for the client in the future. If you settle prematurely and things go south, it could be bad for the client.
Right.
So you're trying to get as much information as you can to see whether or not what you do. Do you have to go to litigation? Do you have a chance to go to mediation?
And obviously, most clients don't want to have to go to trial. They would prefer not to litigate. But oftentimes, you're required to file a lawsuit because there's not going to be a voluntary agreement between the plaintiff and the defendants that a certain amount of money is going to take care of all the problems. And oftentimes, it's because there's concern that somebody else is partially at fault, or particularly that the injury is either not permanent or pre-existed this accident. They had suffered some type of similar problem in the past, and causation becomes a big issue, or there's a fight between the experts that maybe the insurer hires that has out there in their pocket. So you have to try and resolve those issues, usually at a mediation. We'll put together initially a giant settlement package that outlines the facts of the case, the evidence, the treatment, all of that information, and demand an amount for settlement. Normally that doesn't result in settlement. So the next process is what?
So today what we usually do is that we'll engage the services of a mediator. Doesn't have a dog in the hunt. Usually it's an experienced attorney, maybe a retired judge, brings the parties together, and each side has their own view of the case. And the mediator's job is to try to see if they can bring the parties together short of going to a trial. And the reason why is because there are costs associated with trial, there are delays associated with trials.
Long delays.
You can win the case, but then wind up being an appeal for a long period of time.
Years.
So yeah, and so all of those things are things that the client takes into consideration in deciding what ultimately his decision is going to be. We give him the advice, and then the client listens to the advice and says, okay, this is what I want to do. And we do our best to prepare him for what's coming, one way or the other.
Let's describe the mediation process a little bit more detail. Basically, as you mentioned, you got a judge, usually a former judge or lawyer who's has no dog in the fight. They bring the parties together. Their plaintiffs are in one room, defendants in another room. Initially, usually there's a meeting. All sides are at the table. You have the defendants on one side, usually plaintiffs on the other. It's always best if you can have the adjuster for the insurance company or representative of the insurance company there, but you can't always make that happen because they're the ones that ultimately make the decision. Both sides kind of say what their position is, how the story has played out and what the injuries are and what their analysis of it is, and then they're sent off to their separate rooms, and then the mediator does what?
The mediator essentially goes back, we'll back up a little bit. Usually you give the mediator a position paper. Gives you an idea of what the medicals are. The mediator is educated when you walk into the room and then comes in and says, okay, let's go back and forth between the two sides to test the case. Basically to say, well, Mr. Meredith, this evidence is out there that the defendants rely on. How are you going to respond to that? And it will go back and forth. It gives the parties a chance to really see, how their case will hold up through the eyes of someone who isn't interested in it, doesn't have a monetary outcome.
It facilitates communication in a way that maybe wouldn't normally occur if just the defendants and plaintiffs were sitting across the table, maybe even sometimes getting frustrated and yelling at each other. And so the defendants may say, look, we don't agree. That guy was already injured. He'd been in 4 different accidents before, similar things, or he's got a bad history of criminal problems or filing claims or whatever, and they point out something that they think is going to reduce the value of the case or maybe even get a jury to say, we're not giving you a penny. And so the mediator brings that information over to the plaintiff and his attorneys, and they respond with whatever information that supports their position that they're not right, that they're wrong. And that's the process. It goes back and forth depending on what various issues or the big kind of problems in getting a settlement to occur.
And that's what causes the two sides to ultimately start moving toward each other as you get a better understanding of each side's position.
The strengths and weaknesses is the bottom line. And so ultimately, sometimes that is successful and you reach a number, and numbers are thrown back and forth for hours, usually, kind of adjusting based on that exchange of information. And then if a settlement occurs, sign a document and it's over. If not, you can walk out anytime you want. And it doesn't have to happen before you file a lawsuit. It happens during a lawsuit or even after. Sean, thanks for helping me try and explain this. This is a lot of information in a very small amount of time. We'll continue this on the next show. This is Locke Meredith with Sean Fagan. Thank you for being with us.